Hey, good afternoon.
Good afternoon. Today is Thursday, February 27th, 2025, and the Board on Professional Responsibility is convened in the matter of Kevin McCants, Board docket number 23-BD-052. Will the parties please identify themselves for the record, starting with disciplinary counsel?
Jack Metzler for the Office of Disciplinary Counsel.
And respondent?
Oh, yes, thank you. Kevin McCants on behalf of myself.
All right, thank you. We are here on exceptions to the hearing committee report that were filed by the respondent. Who will proceed first? Mr. McCants, you'll have 20 minutes for argument. Do you want to reserve some of that 20 minutes for rebuttal?
Yes, ma'am. May I reserve 10 minutes?
10 minutes? Okay, sure.
Okay, thank you.
You can start when you're ready.
Oh, okay. All right. Um, Ladies and gentlemen of the board, thank you for allowing me to appear. Fortunately, obviously no one wants to be involved in a disciplinary matter. But I just kind of wanted to give my insight from where what I believe brought me here, and my intake of what I believe the how the board should look at things. Um, it's sad to me. It was difficult and sad to say. Read some of the I don't know if it's opinions, but the filings from Office of Disciplinary Counsel say, well, he has a bad background. He's been disciplined a lot, and maybe that is the case, but I don't feel like I've ever done anything that put me in that category, or anything that you say, oh, this person has such a bad history. I mean, I look at specifically these um, these offenses in 2015 was a matter that started in about 2013 that only dealt with, this is the DC Circuit. I've never appeared before them, never met any of the judges personally. I've done two cases there, one with a gentleman named Darren Perkins, who had spent about 15 years or 20 years in jail. And I worked on this case for 12 years. Um, got the support of President Obama, Judge Hogan. A PBS special was made. And when I would go see him, some of the other inmates were like, oh, help me, help me. So I was helping another gentleman that worked there. I mean, that was at the prison with him. And he's like, oh, I'll pay you. I have money coming from a lawsuit from a guard. I'm like, and I know, having been a criminal defense lawyer for years, that a lot of times when guys have been in a long time, they don't, the family's not really paying for lawyers and stuff anymore. So I didn't expect to be paid. But then as we were getting around 180 days for his certificate of appealability, he started saying, well, I want you to put this in. I want you to put that in. And I'm like, wait a minute, we don't have proof of that. I can't do that. So when we had a falling out,
Excuse me, Mr.
his, oh, are we at the 10 minutes? I'm sorry.
I have a question for you.
Oh, yeah, of course, man.
So, with respect to the application, your 2016 application,
Yes.
explain to the board why you think that's not a violation of the professional ethics rules.
Um, well, it could be a violation, but the way I looked at it was my mens rea, my mental standpoint when it occurred, I didn't think I was doing anything wrong. Um, the For 2 years, 3 years, the decision from the DC Circuit was they were sending me letters, and it was stamped personal, confidential. And I had never been through any of this before. I didn't, and then a couple months later, well, they wanted me to go to the committee. I said, well, I'm doing a trial in Baltimore. I'm going from Southern Maryland every day. My office had accepted the filing they sent, and all they wanted me to do which is why I said it got blown out of hand. All he wanted me to do is to withdraw from the case from this gentleman because I had put an appearance in through the night box.
Mr.
And then-
McCants,
Mr.
Yes.
Mr. McCants, I don't want
I'm
to
not really
interrupt
getting to
you.
it. Yeah,
I don't want to interrupt you, but
it's too much background.
you need, yeah.
Okay,
You
let
need
me get to it. Yeah, let me
Okay.
get
And sir,
okay.
sir,
Yes.
I'm just curious whether you,
Yes.
in that 2016,
Yes.
you checked the box no. Did you have, an understanding in your own mind about whether the public reprimand constituted the type of discipline that the court was asking you to disclose in that form?
Yes, sir. Because the question was, were you ever disciplined, and did it lead to your not, being suspended from practicing law? So that was really what I was answering. No, yeah, there was a discipline, and but no, I've never been separated from practicing law. That was more of where I thought it was. That was what the argument that I had made to the Maryland court, because I'm like, you guys know from the CJA applications, from the previous applications that I've mentioned stuff before, and Judge Paula Zink had written me a letter about it. So I'm not going to turn. Yes, sir. Someone
Excuse
says.
me. I mean,
Yes.
Mr. McCants, though, the question, sort of following up on what Ms. Rice Hicks asked you,
Yeah.
wouldn't you agree that when a lawyer is answering questions that are going to be ultimately filed with the court, reviewed by courts when it comes to our disciplinary history and our worthiness of admission,
Yes.
don't you agree that it's incumbent upon you as a lawyer and all lawyers to make sure you have an understanding of the question that you're answering, and then make sure you have an understanding of the facts available to you as you answer that question, especially for your own disciplinary history?
Of course. And and I thought I was following that. I mean, even in here, there was a number of questions from disciplinary counsel in their brief saying, well, you said this, you said that. I'm like, yeah, but what I did was I was sending an update for an application that was pending when I had already made a disclosure. I'm not going to send an update saying exactly the same opposite to people. It was a mistake. I had created the document to be able to write out the answers. And I guess the one I scanned had the correct answers, and that was the one that I filed. And 2 years later, when the disciplinary matter went away in DC, I was just giving them an update. That's what I thought I was doing. So it's kind of hard to say, well, did you understand the questions and things like that? Because it was a mistake what I had sent them.
Okay. Mr.
Yes, ma'am.
McCants, in
Mhm.
our
Yes, ma'am.
moments left, you assert that your sanction is too harsh.
I
Can
do.
you provide us some case law to support that your sanction is out of bounds or too harsh compared to other similarly sanctioned respondents?
Yes. I found no cases where there was no deference to the court that was really the originating court. Maryland says that my explanation was fine, and they had no problem with it. But then DC said comes behind it, and the argument is made, he was misleading you people. And I'm like, these are the ones who made the decision. They took that posture at first until I explained that, hey, Judge Paul is saying, you sent me a letter. I sent it back to you. I knew it was to the committee. I'm not going to intentionally send something saying something opposite. It was an error. I've known people for years. I worked on the CJA panel, and they were like, we believe you. And I was like, there should be some deference to that. All I'm saying is, even if it's I say, and it gets to this level with all these people, if it's a suspension, I don't feel like I've done anything that requires fitness. Even if it was more lengthier sentence, I have no problem with that. But I'm like, I don't feel like I should have to go and basically beg the Office of Disciplinary Counsel, the way I've been treated since 2018, particularly by one person there, to get readmitted. That's all I'm saying. If you guys feel like, oh, we're not comfortable, he seems like he must have been lying. There's no way a lawyer shouldn't have known that when another court says, oh, we have a show cause, the show cause goes 2 years, and then when the other matter that they started the show cause about it is dissolved because the committee dissolves it, and then they say, well, okay, we'll give you retroactive, go back 2 years. I thought just like in criminal defense, the show cause is over. So there was really no punishment. Yeah,
Mr.
it was a
McCann,
mistake. Yes, ma'am.
excuse me. Would you not agree that as an attorney, especially if you're filling out an application to the court, that you have to be truthful and complete in your answers?
Yes. And
Okay.
it's
And if you believe that one person, judge of a court, knew of your prior discipline, don't you think you have an obligation to be truthful and complete in your answers?
that wasn't the case. See, it wasn't so much that one judge knew it. She was on the committee. She had written a letter in 2019 when the inquiry first started in DC. I said, the person that's the chair of the committee wrote me a letter saying, hey, we know about 2019. We know about your previous discipline. You know, what is this? And I'm like, what did I send you guys? I sent something uplifted in an email while I was in a murder case. And I thought I was sending the first application just to let them know that the committee in DC had dropped it. So I didn't think I was sending them the wrong thing. And they believed it because of that. I mean, it just makes, to me, it makes no sense that I would do that.
But knowledge of one person doesn't mean the collective group has knowledge of your prior history.
Well, she wrote, not in this case, because she was writing on behalf of the committee.
But when you fill out an application,
Mhm.
maybe some of the committee members weren't privy to that letter. So to me, it seems like you would have this board believe that you did not have an obligation to inform the entire committee of your prior history. Is that what you're saying?
Not at all. What I'm saying is I knew it was going to the committee because the clerk's office couldn't process it because I had to, they wouldn't accept it because it was late because I was in Seattle taking care of my uncle and they had a portal and the portal had closed. So they said, you have to go to the committee. So I knew it was going to the committee, you know, but don't get me wrong. You know, I started wondering the second time, I'm like, wait a minute. It's a public reprimand, which I thought was in-house because it was every 6 years. I'm like, maybe I should go back and tell them, hey, I have a matter that's sealed. It's a sealed matter, but I want you to know the matter because you guys as judges can look into it. When things blew up, that's the way I looked at it. And I know, yeah, I was wrong. I took the avenue in a way because I didn't agree in my heart with the public reprimand in 2015, and I didn't acknowledge it, but it wasn't my it wasn't my choice to do that. It wasn't fair, and it was very unprofessional, and I deserve the look that I'm getting right now. It was wrong. You know, I did it because I guess I was embarrassed about it. I thought it was wrong because the committee from that one had said that I shouldn't be disciplined. And they said, oh, no, you were arrogant. You didn't want to go in front of the committee. And I was like, it wasn't that at all. I just said I was doing a big conspiracy case because it was the first one I was doing. If I had said that 10 years later, then yeah, that would have been arrogance. But yeah, no, but I knew I should have. I was hiding it after that. The second 6 years, third 6 years, I was like, I should have answered it the other way. But I'm like, are they going to have a problem with the way that I answered it before? So it's like they say, one small lie leads is to cover up. So I should be disciplined. I was wrong, but not to a point where I feel like I should have to do fitness and do 9 months. I'm like, I've done over 10,000 criminal cases in Superior Court with no problems, great relationship with the judges. And because when I read these things, oh, well, you're disciplined here and there, I'm like, all this was another court saying because you went through a discipline process that dissolved and the committee found you not liable, not guilty, we're going to go back and make it retroactive. I didn't think that was a discipline. That one I'm going to say was a mistake on my part. And I didn't think that was something that I had to go back and say, oh, well, they went back 2 years and said that they were, no, I didn't think that. But I should have told the federal court of Maryland the first time. They did a seal matter, but you guys can look into seal matter because you're judges. So yes, ma'am, I know I was wrong.
Mr. McCants,
Yes, ma'am.
you've been saying a lot of things,
Too
but
much.
really we're here because on 3 separate recertification applications to the Federal District Court in Maryland, you were asked a simple question. Have you been denied admission to practice, disbarred, suspended from practice, or disciplined by any court or bar authority other than administrative suspensions for non-payment of dues? When you filled it out in 2016, you had been reprimanded in 2015, you wrote no. That's a false answer. In
But that's the
2020, in 2022, you had been disciplined in 2021 or 29, you had been previously disciplined before 2022. In addition to your 2015, the first time you filled out the application in 2022, you checked yes.
Yeah.
You partially disclosed something and you submitted information about your second discipline, but you didn't sign the application. Then in 2023, because your application in 2022 was rejected because you didn't sign it, you submitted new papers. And the question that you'd answered yes in 2022, you answered no in 2023. That's all correct, right?
Correct in a sense that is correct, and that's what went into the court. But what's the missing context part is I uploaded an application from the previous year to give them an update because they said give them an update with what was going on with the new discipline matter in DC. And when the committee ruled in my favor, that day I went to my I went right back to my office and I uploaded and I sent them a copy of the transcript, the briefing order. So it wasn't like I wasn't trying to say it happened. I just sent the wrong application. I should have sent the one that it had been scanned and I wrote instead of the one that I had in there's a sample. Because their application's online and you got to answer their questions, but you got to print it out and sign it and all that. Because the whole thing was after the first one in 22 was I needed a wet signature. They only wanted my actual signature with it, not to go electronically. So I'm not going to intentionally send one saying the opposite things with the same person, head of the panel, a judge that I know from CJA panel and from civil cases and just know well from different circles, to the exact same person over the committee who had just wrote me saying, hey, we, about the 2019 thing.
Mr. McCants?
Yeah, the time is up.
The hearing committee did not credit your testimony before them on these issues and these questions.
Right.
And the board, why is the board not constrained to accept the hearing committee's credibility findings with respect to your explanations? Again, the hearing committees found them, did not credit them, did not find you credible. And in fact, in one case on a particular issue said your testimony before them was false on a particular question, although they did not include a finding of false testimony in the ultimate analysis. So how are we, the board, the hearing committee is a finder of fact. They have not credited your explanation of these matters. On what basis are you asking the board to step in and upturn the hearing committee's determinations on your credibility?
Mr. Walker, you make a good point. I don't really see how you could. That's the way they felt. I felt like they were improperly influenced by disciplinary counsel and the way she argued it, and she wasn't truthful with some of the things, but I put myself in that position. If I was on the board, I would have an uphill battle with the things that I'm saying now. I'm gonna say, well, it happened. You should have figured out. But if you don't live in an environment where you're thinking in terms of, oh, well, this means discipline, this means that, I wasn't thinking in 2019 that when they said, okay, the show cause is over, we're going to go back 2 years, that's something that I needed to report. I just wasn't. I made a mistake. Same thing when they did it in 21. To be honest, I was scared when they were talking about a show cause. I thought they were going to take actions if the show cause would have went forward. When they said the show cause was over, I felt kind of like I had won, and once again, I I've never been in front of the judges there, and I don't know them. They don't know me. They were going just based on something that happened in another court. When it was over, they said, hey, the letter was kind of celebratory a little bit. It was like, you finished your probation with no issue, when I did the one negotiated settlement, which I felt like even that one I shouldn't have done, because, you know.
Mr.
I mean,
McCants, so in
yeah,
this matter here, you're
yes.
saying, basically, the way I heard you answering Mr. Walker's question was to say, yeah, you're right, your hands are tied, board. You have to take their finding. Is that what you're saying?
No, I'm not saying it at all. I think you guys should look at it de novo, but I know that, you know, in 2015, when it really came down to it, I fudged the answer because I was embarrassed and I shouldn't have did it. But I don't think it's enough to make me have to go fitness to get back in. I mean, I ain't robbed the bank. I've seen people do some really bad stuff to get disciplined. I thought that, well, it's sealed. I shouldn't really have to tell them, and I disagree with the finding. That was really it. And that was a bad mistake. It was something that had went for years. And when it was over, it still says sealed. So I was like, okay, well, I guess it's between us. But when I thought about it, I should have said, hey, I had a seal matter. You guys can look into it and make whatever you want from the seal matter, instead of just acting like it didn't happen, because I didn't get them all the information. So I do accept that I was wrong. But I'm like, maybe, do we compare that with, going back to fourth grade, where I'm trying to live a life of a future lawyer and trying to do everything right, I don't know. I just feel like, ethics has to look at the total person. And yeah, I did disagree with the committee. I respect the committee, but I disagree with the committee saying, oh, well, he was lying with this. I'm like, you can say you didn't agree with the decisions. You didn't think that, you didn't believe his explanation, but it had to be something there for Merlin to say, oh, it makes sense, because they really, really, really were upset with me with the letters that they sent. I have letters here at first, when they were like, hey, you didn't say this, you didn't say that. And I was like, oh, it was a mistake, and this is what's going on. I just sent you guys the application. I just wanted you to have an update, because you told me to give you an update when the DC matter was over. I wasn't trying to pull wool over anybody's eyes. That wasn't my intent. I didn't have any reason to.
Okay, I didn't finish your sentence. Finish your
sentence. I say I didn't have any reason to. It wasn't like that would have, in my mind, a public reprimand would have kept me out of, or the same court saying, years later, because no charges were sustained, we are gonna go retroactive 2 years later, and because you didn't mention that, they didn't say, okay, we don't want you to be part of our membership. And I just feel like that should have been respected and followed. But if it's not, then I still shouldn't have to be in a position where I got to go through the fitness part, because the word among lawyers is you got to do the fitness. That's like the kiss of death, so that's why I'm like, hey, double it, triple it, whatever you feel is fair. But I don't feel like I should have to do the fitness part.
Okay, thank you, Mr. McCants.
Okay, thank you for asking the question.
Disciplinary counsel.
Thank you, and may it please the board. Just a few responses to Mr. McCants. To begin, the hearing committee found that he intentionally lied and gave false answers on 3 occasions to the Maryland District Court when he was applying to be readmitted. And what I heard just now is he admits that he did it, and he did it on purpose. He says, I fudged the answer to get back in. He said, one lie leads to another. And he said, he was trying to cover up what he had done before, because he recognized that, he had lied. And Ms. Hicks, just go back to one of your first question, which was, you've got a form sitting in front of you, and it says, have you been disciplined? Yes or no? It's a pretty easy answer. It's not like, well, that case was, that case was sealed, or, well, to me, it was it seemed like a victory because there was a show cause that was eventually dismissed. The answer to have you been disciplined when you have a reprimand is yes. The answer to have you been disciplined when you agreed to a negotiated discipline, that's right there in the title, to be suspended or to a suspension and that was stayed in favor of probation, the answer is yes. As the hearing committee found, the respondent knew that the answer was yes, and the explanations that you're hearing today are the same ones that the hearing committee did not believe and found were false. And I encourage you to look at page 8 to 9 of our brief. I think we've cited 9 different statements that that the respondent made today, that he made before the hearing committee, and that he made again just now, all of which the hearing committee found were false. And
Mr. Metzler, I have a question for you.
Sure.
Would you say that Mr. McCants, or have you considered whether Mr. McCants's conduct in this matter reflects a continuing and pervasive indifference to the obligations of honesty in the judicial system, such that a determination of flagrant dishonesty would have been or would be in order?
I think, I don't know if you're quoting directly, but that sounds similar to the language of the Tun case and the Tun 3, and the facts here are similar to that. We didn't take exception to the recommendation here, but I think it is certainly within the board's purview to consider that question. Just a couple more responses. I just want to clear up. You could find this in the hearing committee report, but just because they were mentioned here, I'd like to mention them.
Well, Mr. Meltzer, could you take a little further your response to Mr. Walker's question? Is disciplinary counsel saying that you would not support a finding of flagrant dishonesty, or that you would, or that if somebody wanted to, they could? Could you give us a little more of your considered view about that?
Sure. I mean, I think if you look at the Tun case is actually similar in several respects, and I'll give you the site since it's.
We can look it up.
Okay. Well, it's Tun 3 from 2022. And that case involved a pattern in which Mr. Tun had repeatedly lied in applications back for readmission about his disciplinary history over a number of years, similar to this case, and the result was disbarment. So I think if that were the board's recommendation, I doubt we would take an exception to it. If that. Yeah, actually, I can tell you we would not take exception to that, to that finding, and I do think it's within the board's discretion and role to consider the sanction de novo. I just wanted a couple additional things I wanted to mention. One is he keeps referring to a sealed case. That was the title of the case. The underlying case that he was representing, the defendant, was a sealed case. His disciplinary matter was not. So even though it was called in re sealed case, that's because it was an order that happened. This is the 2015 discipline. So even though it happened in a case which was sealed, the discipline itself was not sealed. With regard to a couple of things he said that he had already disclosed the 2019 discipline. I believe he said that just now. That is categorically false. He never disclosed that in any of his applications.
Mr. Metzler, for the record and for protocol's sake, would you please say respondent or Mr. McCants or counsel? You repeatedly saying he.
Very well. So in the 2019 the 2019 discipline was not disclosed in any of the applications. And then the last thing that I would clarify with regard to your question, Ms. Hicks, is that the sequence from 2022 to 2023 was as follows. He had the 3 prior disciplines, and in his 2022 unsigned application, he answered yes to the 2 questions. But I think it is best, I'm sorry, Mr. McCants answered yes to those questions. And he attached some filings from a separate disciplinary matter, not the 3 disciplinary orders that had been previously happened were not disclosed, but from the ongoing 2022 matter. So I think it's best read as he was disclosing the ongoing matter, but he did not disclose any of the prior matters. And so then after that application was dismissed for failure of the signature, Mr. McCants submitted a new application in 2023. And at that point, he had received a preliminary non-binding determination from the hearing committee that there had been no violation in the 2022 case. So I think it is wrong to interpret that case was ongoing. It was being briefed before the hearing committee and post-hearing brief. And ultimately, there was no finding of discipline in that case, or no finding of violation in that case, but is incorrect to conclude that the case was over while it was still pending before the hearing committee. So in the 2023 application, then Mr. McCants did not, even if he says he was updating them about the 2022 ongoing matter, he still then went and answered no to both questions about the 3 prior instances of discipline. So I think the best way to read that sequence is in 2022, Mr. McCants did disclose the ongoing matter, but when he updated that application or resubmitted it in 2023, he removed the references to the 2022 matter. And even if you accept that's what was going on in both applications, Mr. McCants did not disclose the existence of the 3 prior disciplines, including the negotiated discipline, including the reciprocal, and including the DC matter from 2015. I think those are all the clarifications I had. So if the board has other questions, I'm happy to answer them.
Yeah, Mr. Metzler, how would respondent under these circumstances prove fitness in your view?
Well, a respondent would have to, so after the period of suspension is run, he would have to come back and establish to the satisfaction of the hearing committee that he was rehabilitated. And, you could do that through the Roundtree factors, which would evaluate, what has he done to remedy past wrongs? What has he done to in the intervening period? What has he done with his life? Has he kept abreast of the is he showing remorse? Does he really understand the gravity of his conduct? And often there are character witnesses that attest to the change that in an attorney's life since being suspended, that then the hearing committee can evaluate whether this is true. Does he really understand? As I listen to Mr. McCants today, and you can sort of hear it. He's like, well, yes, I covered it up. Yes, I lied, but I really don't think it was all that bad. He thinks this is an okay thing to do. He would need to show at some point that he understands it's not. And it's not, well, if you think about it, from my perspective, I didn't want people to know. Well, you didn't want people to know you were disciplined. Sure, nobody wants people to know that, but the responsibility is to answer truthfully. And if he would have to demonstrate to a hearing committee that he really understands that. that, he takes it to heart, and that real harm comes from these things. Attorneys need to be trusted to tell the truth. Courts rely on them, and clients rely on, the entire system depends on having faithful advocates there making their best case. And that's how we get cases that do justice in our system. And when an attorney just thinks, well, but not me, I don't really have to tell the truth, I do other stuff that's good, that just doesn't cut it. That's not the way our system works. The last thing I would say with regards to the sanction is, there's a good quote from the Tun case, which says that an attorney's lack of candor with a judicial tribunal, especially under the penalty of perjury, casts serious doubt on his fitness to practice law. And I think that describes this case very well. Regardless of the period of suspension, there is a serious doubt about whether Mr. McCants is fit to practice law, because he doesn't appear to recognize that he has to tell the truth all the time, even when he doesn't want to, even when it might make him look bad for something he said earlier. That's the obligation. That's the deal when you become a member of the bar. And right now, there's a serious doubt about whether he is able to do that. If there are no further questions, I'm happy to rest on the briefs, or otherwise answer anything else that the board would like to know about.
Any questions for Mr. Metzler? Okay. Mr. McCants, we'll let you have time for rebuttal.
Okay, thank you. I'll be brief. I appreciate the extra time before. The Tun case involved financial theft, billing the court for CJA work that wasn't done, and just matters that were completely different. The matter with me, disciplinary counsel is been extremely reckless today. Either they don't know or intentionally misleading this board. The matter that I was disciplined for, that came out in 2015, it started in like 2013, was Craig Williams. That was the case that I was involved in, United States versus Craig Williams. It became in re seal when they dealt with the discipline part. So that is untrue. And what I said was not so much that I was trying to mislead them or anything like that. I just didn't know. I did benefit. I did it in a way where, yeah, I felt like, I had such a good relationship with the judges up there. I didn't want to be looked at. Didn't want them to know about what had happened in 2013. But I thought, because it was sealed, that it was something between me and them. And until Ms. Tate found it years ago, I thought it was something that stayed in their courthouse. And then for him to say I never talked about 2019, I mean, that's got to be the first anybody here has heard that. It was in the earlier application, it was in the application. We talk in terms of 22 and 23, but realistically, we talking about a couple months later. I had submitted it when I got back from Seattle, and I said, hey, this case is this lady, Miss Tate, done brought another case for me. I was, and I was telling the judges up there, I'm like, I have almost 600 emails. This lady investigated me 40 times and then got rejected every time. This is, and that's why one of the things about like fitness, why I don't want to get into my life with the Office of Disciplinary Counsel about where I've been and where I work at, because I know of someone named Tito that committed suicide because Ms. Tate followed behind people sending letters to their jobs. Hey, I got a nice job. I'm moved on with my life. Yes. Okay. I made a mistake that I should have told them I had a sealed case. But once again, this was all about an appearance and withdrawing from a case, whether it was when the clerk told me to do it electronically. And I'm like, look, that guy's a jerk. I done returned his money to his lawyer. I don't want nothing to do with it. And it went to, I didn't think in terms of this is a panel of federal judges. Then it went to the full panel. And yeah, they slammed me, but to say, well, he acted incompetent. I'm like, all I did was not withdraw from a case that I just didn't do. I had done it through the night box, and they wanted me to do it electronically. And I didn't agree with the decision. But yes, I will agree with disciplinary counsel. They had everybody had a right to know, but you know, yeah, they knew about it. She had already written me. And what I don't like about what disciplinary counsel did is when I first told them before this whole thing started, I said, wait a minute. They knew about it. The person that I had to write back, the reference person, Judge Sink, is the one that wrote me. Oh, well, find that letter from 2019. Find the letter. So then when I did find it, then all of a sudden now it's a different analysis. Oh, you need to have told the whole committee. Well, you didn't. You mentioned DC 2019, but you didn't say that it was a negotiated settlement. I'm like, there was nothing else but that in 2019 with the DC Court of Appeals. That's all I'm asking is I think that a lifetime of honesty should stand for something. I think that a person can make a mistake and it not mean that I got to lower myself as a man to beg disciplinary counsel to practice again. Because if that's the case, then it's over with me for life, and I can live with that. Because I don't like the way they do business, and I won't do business with them. But I respect this board. I appreciate it. You know, I admit that I did in the second 6-year one say, wait a minute, even though it's sealed, because at that time, Ms. Tate found out about it, I should tell them, and I was scared. And I didn't do it because it wasn't nothing they could do except for say, you're not on our panel no more, you're not a member there. But I mean, there's so many cases. So, I mean, it wasn't like life was going to be over, but it was just, I don't know, it was more of an embarrassment thing. I didn't agree with it. I made a mistake. I'm here to say I made a mistake, but I don't feel like I should have to deal with fitness. I say that as a professional. I know I've said it multiple times. I want to thank each of you for conscientiously asking questions from both sides and really thinking about this matter. And I appreciate it.
All right, thank you, Mr. McCants. Any questions for Mr. McCants? All right, thank you, counsel.
Okay,
This matter, did you have something to say, Mr. McCants?